Item number 1.
May it pleases your lordship.
Yes.
My lord, this PIL is pertaining to non-availability of the Anganwadi centers in villages, lordship, which the petitioner had made a survey, lordship, under the Miao and Bardumsa circle, lordship. So each and every day, there is violation of right to food of the children who are entitled to get food from the Anganwadi centers, and also for the pregnant and lactating mothers, lordship, of that locality of the Anganwadi center, and violation of Section 4, lordship, and Section 5 of the National Food Security Act, lordship. So notice is already being issued on 15/5/25, lordship, but till date, no affidavit is being filed, lordship.
My lordship, our affidavit is ready, but annexures are not clear, my lordship. So we need some more time, at least 1 week.
When the notice was issued,
On 15/5/25, lordship.
more than half year over.
We have almost a year, lordship. Now we are in the end of
Why
almost
could not
March.
we impose some cost upon you?
My lordship, our affidavit is ready, my lordship. Only the annexures, some annexures are not visible properly.
So when you were going to file it?
Within a week, my lordship.
Within a week. Let them file.
Yes, lordship.
Heard Ms. D. Ghosh, learned counsel for the petitioner. And also heard Ms. Wangmo, learned government advocate for the state respondent. Ms. Wangmo submits that her affidavit is ready, but the same could not be filed due to some
Annexures that are not visible.
as
here.
some of the annexers she has received from the respondent authorities are not legible, and she pressed for 1 week time to file the affidavit in opposition. Here allowed, recital is the matter.
Lordship,
After 1 week, or we'll fix a date.
date, lordship, since I am an outstation counsel, lordship, I'll humbly
Suggest a date.
after,
View.
after Bihu, lordship.
Okay. On 21st of April.
21st of April, yes.
Your lordship, I'm appearing on behalf of DHG M. Kato for respondent number 3, your lordship.
Is your name, please?
O. Jerang, your lordship.
O. Zeram, learned counsel for the respondent number 3,
Three.
appearing on behalf of Mr. M. Kato, learned counsel
21st,
for
he
the
said, no?
31st.
Much obliged, your lordship.
31st.
31st.
When?
21st, right?
21st.
21st. Saturday. Deeply.
Item number 2. 21st.
Lordship.
Hmm.
This is a PIL, lordship, with regard to issuance of wherein a notification is challenged, wherein it says that temporary residence certificates will issue to Chakmas and Hajong. But if it's a temporary residence certificate, we have challenged that notification, lordship. And if a temporary certificate is issued, then it's difficult for them to apply for job, even in private companies also. So they need residential certificate. If not permanent, but at least a residential certificate for them. And in fact, their names are also there in the voters list. They are enrolled, and since decades they are there in this state, lordship. And most of them who have migrated from erstwhile East Pakistan, 90% of them died. And most of them who are residing right now are citizens of India by birth, lordship. And in fact, Honorable Apex Court in one of the judgment also held that the atrocities being inflicted upon them, lordship. National Human Rights Commission versus State of Arunachal Pradesh and another, lordship, in 1996, 1 SCC 742. So the plight of the Chakmas in the state, lordship. So if it's our humble prayer is issuance of a residential certificate. They are residing in this state, only residential certificate. Because if they apply for government job also in central government, in military, if it's temporary, they are not getting the job. So this is the difficulty, Lordship.
So, Madam, you say
Yes,
the
Lordship.
order dated 25th of February 2026,
Yes, Lordship.
this court
Yes, Lordship.
has observed that maintainability of the PIL shall be considered on next date.
Yes, Lordship. PIL is maintainable. One reason is that each and every person approaching, it will be difficult. So the student union, Chakma Student Union and Hajong Student Union, on behalf of their community, they are representing the plight of them, challenging the notification of that, Lordship. It's maintainable, Lordship, and even a students' union can come up because the students who are going outside the state for studies also, if they don't get residential certificate, then for them also, those students also, they are representing the students as well as the citizens who are applying for jobs also, Lordship. So these students' unions are also taking the plight of the students who are studying out, intend to study outside, but if a temporary certificate is issued, so for them to get admission in institutions are difficult, Lordship. They need only residential certificates. They are not asking for, in fact, the permanent resident, but residents. They are residing in this state. So they just require the resident.
Is there any difference between permanent residential certificate and residential certificate?
So on their behalf, they don't have any issues if it's issued to them, but they need residential, not temporary. They are residing here, their names are enrolled in the voters list. So how they will be a temporary resident? Their names are there in the voters list, Lordship.
Annexure 12,
Hmm.
it is clearly written the temporary certificate.
Yes, Annexure 12, Lordship,
Page 89.
page 89, Lordship. Temporary residential certificate not accepted. So in fact, they have the domicile certificate or permanent residential certificate, the temporary residential certificate not accepted. So it's from the Director General of Assam Rifles. So this notification. So if it's a temporary residential certificate is issued for, and for them it's difficult, Lordship. And in fact, page 90 also, Lordship, provisional appointment letter, in that also either they require domicile certificate or permanent residential certificate. Temporary residential certificate not accepted. So these are the difficulties being faced by them, Lordship, by the community.
But whether the student union can represent all those persons?
At least the students, Lordship, those who are going outside for studies, for students also, if a temporary residential certificate is issued, it's difficult for them.
The student were in it.
Students are also in need, Lordship.
Yes, Mr. Nagam.
My lord, since the other side they have said, my lord, referring to is Bangladesh, my lord. They have migrated somewhere in 1960s, my lord. My lord, may I kindly remember, my lord. My lord, they are neither invited nor accepted by the government of India. They are the intruder, my lord. My lord, during 1967, my lord. Now, my lord, so far, my lord, mentality of this present PL, my lord, I raised these questions. Now, the other side, they have said, the first, second generation, my lord, they already died. They took birth here itself, by birth itself, under the provision of the Citizenship Act, they become automatically citizen of India, my lord. If you lordly remembers, my lord, during last election also, my lord, there was clear-cut communication or instruction from the Ministry of Home, my lord. Voter list, Aadhaar card, PAN card does not prove he is a citizen of India, my lord. Admittedly, no doubt, my lord, except that some of the names of the Chakmas are enrolled in the, my lord, voter list, admittedly. But as per the ministry notification, that does not mean that he is a citizen of India, my lord. So far, by birth itself is concerned, my lord, I think matter is sub judice before the Supreme Court, my lord. Automatic, my lord, citizenship of India, my lord. Your lordship may kindly remember, their forefather, my lord, they are illegal intruder to the, my lord, in the India, my lord. They are neither invited nor, my lord, we welcome them as a, my lord, some sort of, my lord, political asylum or something like that, my lord. Illegally, they have intruded, my lord. So, if their parents is illegal, my lord, intruded, my lord, their offspring, can that be a automatically citizenship of India or not, my lord? That question is, if I correctly remember, is pending before the Supreme Court, my lord. Now, my lord, so far, my lord,
In whose matter?
my lord, exactly, I don't remember. PWD Assam, something like that, my lord.
No, that is for Assam, not.
Oh, no,
for-
no, citizen is for all. Because they,
That is 6A challenge, Lordship. That is
Correct.
6A challenge.
Correct.
6A challenge, that
No.
is with regard to
the question,
state of-
no, question is automatic, my lord, citizenship India. That is the moot question, my lord.
That is already judgment
And
delivered.
that, I think, my lord, that is still pending before the Supreme Court, my lord.
No.
That having said that, my lord, so far, my lord, in Arunachal Pradesh, we have only two concepts, my lord. Permanent and temporary. There is no other, my lord, concept, my lord. Either you become indigenous and permanent resident of the Arunachal Pradesh, or you are a temporary resident, my lord. Now, my lord, so far these Chakmas are concerned, my lord. I don't have any personal grace, my lord. My lord, they have been, my lord, given some plot of land, my lord. My lord, with or without consent, my lord, those days, from the 1960s, my lord. Now, there are certain, my lord, special provision which protects the, my lord, citizen of, my lord, indigenous people of Arunachal Pradesh, my lord, who can have the permanent residence certificate, my lord. As I've said, my lord, these are the all welcome guests, my lord. How come, my lord, they have a permanent residence certificate, my lord? That will be in violation of those special act, my lord, which I'll be, my lord, dealing when the final argument is pledged for your lordship, my lord. That is the reason, my lord, now how to, my lord, solve the problem, my lord. The children, they are saying, my lord, for their academical or for their job or some sort of facilities, my lord. My lord, we recognize, my lord, we give them all sort of facilities, my lord, whatever they are entitled, my lord.
No,
My lord,
in
to
some
solve
of
the-
the central government institution that has not been recognized. You see this page number 89, annexure.
My lord.
This is the notification issued by the
Assam Rifles, Lordship.
Assam Rifle, Shillong.
My lord,
Here it is clearly stated that temporary residential certificate not accepted.
my lord. My lord, that part, my lord, I can understand, my lord. You also may kindly see our part also, my lord, the difficulty we are facing, my lord. We cannot issue them permanent residence certificate. This has to be issued only to the indigenous residents of Arunachal Pradesh, my lord. When we say indigenous, my lord, I'm sorry, my lord, they are not indigenous, my lord. Now, my lord, how to sort out this problem? We try to come out with some mechanism, my lord, by giving, my lord, temporary residence certificate, my lord. My lord, the central agency or the central government ought to have accepted, my lord, by considering, my lord, the present situation, my lord, especially the Chakma brothers and sisters, my lord. My lord, now for that rejection, my lord, the central government, my lord, I think they will the right person to answer that, my lord. But we try to help them, my lord, giving, my lord, temporary certificate,
No,
my lord.
whether central government is a party here.
Yes, my
Yes, Lordship.
Okay.
But the present PI, Union of India is not a necessary party. Because here, the petitioner grievance is projected against the state government. They are basically agree with the.
No, you
Oh, no.
annexer 12.
12.
For that, they have to make Assam Rifle as a party.
It's under the union only.
No, you can represent the Assam Rifle.
Yes, union.
Here, they have not been made as a party.
No, Assam Rifle is not a party, agreed.
Yes.
But
Union
you
is a
are-
party, is
you
under
are-
the union.
Central government is a party. You are representing the central government, so you can represent them.
But Lordship, here it has been specifically mentioned, Union of India represented by Secretary, Ministry of Home Affairs, Lordship. And Lordship, here Assam Rifle comes under the Ministry of Defense, Lordship.
No, paramilitary, no.
Yes, it's under the
Ministry.
Home Ministry.
Home Ministry.
It's under Home Ministry.
Paramilitary.
Home Ministry. And after all, union government has settled them in this state lordship. So obviously, a union stand, has to be very clear, because under the union government, these people are settled in this state lordship. So union stand is very important. And in fact, union stand was very clear while in Delhi High Court challenging the election case, wherein they have said, yes, those who are by birth, their name has to be enrolled in the voters list. And this is the reason their name are now being enrolled. And thereafter, full bench of the election commission lordship. And as per the direction of the election commission only, their names are enrolled. And after proper verification, it's not easily that their name are enrolled in the voters list. After proper verification only, their names are enrolled in the voters list. So in the case of 1996,
You say here notice has already been issued.
yes,
The
Lordship.
parties have entered appearance.
Yes, Lordship. No
File
reply.
your affidavit.
Yes, Lordship. No affidavit is
Mr.
being
Nava?
filed, Lordship.
My lord.
File the affidavit in opposition.
My lord, let this come after vacation, all right? Then in the meantime, we'll file the affidavit, my lord.
So
Okay.
21st, I'll pray since
Uh,
I'll come for one case
21st.
together.
21st.
Heard, Mr.
21st.
Digos,
Can it be May
for the-
4th? May 4th.
Mr. R.S. Learned
I'll be looked.
additional
So 21st is only other PI
government,
also. is-
no, additional advocate general
So
for
if you
the
just
respondent
give
number.
affidavit, that
So
also.
let's see.
For the respondent number 2, 3, 4, 5,
My lord, I am 2 to 5, my lord. 2 to 5.
and Mr. Your name, please?
Yellow.
A lawyer for the respondent number 1.
One.
Respondent number 1. While keeping the question of maintainability of the PIL is open, the
Well,
respondents are directed to file their affidavit
My lord.
on or before.
My lord,
Oh,
honor for my lord,
21st
the sister, she suggested my 21st April, my lord.
Yes, 21st.
The three of my lordship.
Item number 3.
Yeah, in this writ appeal, we are supposed to file our affidavit. In fact, the main writ petition also was disposed of without, in the motion stage itself, where we didn't file our affidavit. It was disposed of, dismissed on non-maintainability, non-joinder of necessary party. So we will be filing our affidavit.
When?
Let it be after.
Your Honor, in this case, the mandatory party is the ERO, and I have made him party.
Mandatory?
Mandatory party is the ERO. We have, in the writ petition earlier representation, I have came to the court appealing the authority to intervene in the representation that I have submitted to the ERO.
Mm.
And that is in my writ petition, Your Honor. I have made the party ERO. ERO is my party. He is the mandatory party in this in the earlier writ petition. So the question of maintainability does not arise here, Lordship. And it has already been admitted in the re-appeal.
Okay, let them file their affidavit.
My lord,
Heard, Mr. Your name, please?
Sitatak.
Tatak, learned counsel for the appellant, Mr. A. Rotten, learned N. Rotten, learned counsel for the learned additional advocate general for the respondent number 1, 2, 3. For all the
not two, not two, my lord.
1,
1, 3, 4, 5. 1, 3, 4, and 5.
1, 3, 4, and 5. And you?
Lordship, I'm appearing for 2 and 6.
2 and 3. Miss,
2 and
your
6.
name, please?
2 and 6, Your
2 and 6. 2 and 6.
Key lawyer.
Okay.
Yeah,
Mr.
yeah.
Rotan submits that he may be granted some time to file affidavit in opposition. Fair allowed recessal is the matter after
After 3 weeks, my lord.
after 2 weeks.
Okay.
After 2 weeks.
Blessed.
Item number 4.
May I please, Lordship?
Yes,
Lordship, I was appointed as a legal aid counsel
yes.
here. Then after receiving the necessary documents, I have drafted one this condonation of delay, and the convict is in Teju jail.
Yes.
So through registry, I have filed application for swearing of that
Affidavit.
application. Yes. So this matter may be reached after 1 week. By that time, I think application will come.
Okay. Heard Mr. Bori, learned
2 weeks, Lordship, 2 weeks.
2 weeks.
Yes, Lordship.
In the meantime, he will file and serve us the copy, my lord.
Yes.
You will file?
In the meantime, let him file this and serve us the copy of this IA, my lord.
Okay.
Yes.
Heard Mr. Bori, learned legal aid counsel for the appellant. And Mr. Ite, learned additional PP for the state respondent. Mr. Bori submits that he has received the relevant papers from the registry and he has prepared one petition,
Yes, for
For
condonation of delay.
condonation of delay, and also prepared appeal memo,
Appeal memo.
and he tries for listing the matter after 2 weeks so that he can obtain the signature of the appellant from jail through the registry of this court.
Yes.
Fair allowed, recess shall list the matter. We'll fix the matter
Yes, my lord.
on suggested date. 7th of April.
Yes,
Okay, my
Lord.
lord.
Okay.
Seven.
Oblige.
Oblige, my lord.
Item number 5.
Lordship, this is preventive detention, Lordship. Lordship,
Whether the affidavit has been filed.
Lordship,
Mr. Nawab,
and my lord, affidavit, my lord, here. Respond number 4, my lord, affidavit is very important, my lord.
who is the respondent number
My
4?
lord, Zonal Director Narcotic Control, my lord,
Itanagar.
Itanagar. And they sent a proposal to the, my lord, Commissioner Home for further detention. Based on their recommendation, my lord, that order was issued, my lord. So his affidavit is very important, my lord.
So when you are going to file the affidavit?
My lord, they have their own standing counsel, if I correctly remember, my lord. They have, yeah. Ab iper nahi karta PP ka. Nahi karta hai.
No. Lordship, I am representing respondent number 3, 5, and 6, Lordship.
2, 3,
3, Lordship, 3, 5, and 6, Lordship.
3, 5, and 6.
Yes, Lordship. And we received instruction from the respondent number 6, the superintendent of prison, Lordship. That we comply the detention order only, Lordship. We have no role, Lordship. The best person would be the zonal director, who sent the proposal, Lord.
Okay.
Then, my lord, I'm sorry, my lord. Then Commissioner, my lord, home affidavit may be necessary, my lord. I will be taking some more time, my lord, for that, my lord.
Okay. Heard Mr. Tapak.
Lordship,
learned
may I,
counsel for the-
Lordship?
Yes.
Because Lordship, this is, first of all, this is not a civil case. This is a criminal case. Preventive detention, there is nothing in a live link. And there is already the petitioner is inside the jail, accused is inside.
No.
This last
Unless they file
four
their
months.
affidavit in opposition, how can we examine
some
whether that
short
is
date may
live
be
link or
given.
not?
We have compliance already, filed compliance affidavit also with regard to respondent number 4. That may be presumed served, Lordship. Respondent number 4.
No, Mr.
We have-
Nakami is
we have-
representing the respondent
have
number
filed-
4.
Who is representing 4? No, nobody is representing 4.
No,
That's zonal director.
zonal director, yes.
Nobody is representing. That is the issue here.
Unit Director,
Yes.
Narcotic.
And the narcotics.
Is it under the government of Arunachal Pradesh, central?
Central government, I think.
Central, then we don't represent, if you clarify that.
Yeah. That is it.
No, who passed the order? Detention order.
Secretary Home.
Secretary Home.
Secretary.
Yes, Secretary Home can clarify the matter.
The secretary whom has to file the
Yes.
affidavit.
Yes, but
That
that's
is-
phone number
that
two.
is-
That's
that
what
is
we asked
relevant.
for time, my lord. That's why,
So 1 week?
my lord, let it also come, my lord, after break, my lord, 20.
No, 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 no,
Particular,
no.
they
no,
give.
no.
Because this is a
Preventive
detention
detention.
matter, urgent matter.
Heard Mr. T. Tapak, learned counsel. Petitioner, Mr. R.S. Nabam, learned additional advocate general for the respondent number
One and
1,
two, my
2, 1 and 2.
1, 2.
And Mr. Your name, please?
Dilo, Your Lordship.
Learned counsel for the respondent number 3, 5, and 6. 3, 5, and 6.
Fifth, Your Lordship. Public Prosecutor. Public Prosecutor, Your Lordship.
Public prosecutor.
Yes.
Public prosecutor.
Correct.
3, 5, and 6.
Mr.
Mr. Nabam submits that he may be granted some time to file affidavit for the respondent number 2. Respondent number 2. They are allowed recessal is the matter. On.
My lord,
Mr. Tapak suggested that
today is my lord 24th, my lord. I have
31st of March,
31st March. That will be
31st March.
Tuesday.
Tuesday. Sufficient time. That the government has to reply, because this is a detention matter. That too, she is a mother, lactating mother.
Item number 6.
None appears for the applicant, struck appellant on call. Leave the matter. You are for?
For the State Lordship.
And Mr. So-and-so, learned PP for the state respondent. List the matter after a week in the event of subsequent non-representation of the appellant. Struck applicant, appropriate orders follow.
Item number 7.
Wait,
Yes.
appellant my lord challenges the judgment and order dated 29/5/2023 and the order of sentence, my lord, this is under 302 and various sections, imprisonment for life. There are absolutely no materials on record to sustain the conviction. Various
So what are the materials the trial court has?
160,
relied upon?
164 matter without any corroboration.
164. The
Without
confessional
absolutely no corroboration, matter.
confessional statement.
Yes. My lord has seen this is happening in this state. Lots of cases, 164 and like this, convictions are there. So many material witnesses were not examined. The weapon of offense was also not produced. Not exhibit.
No. Is it your case that the weapon of offense was recovered and seized but not produced before the court?
Yes, that is, they say so, yes. They seized it. This state will, your lordship will find it in the statement of the IO itself. These are witnesses. These are witnesses who purportedly were, these are witnesses to the weapon of offense. Some of them were not examined and some have denied. There absolutely no evidence, man.
No, there may not be any direct evidence, but whether there is No circumstantial evidence also.
No, my lord, nothing. In my humble understanding, nothing, my lord. I can take your lordship through the depositions, man.
Yes.
The FIR, my lord, will find at page number 3.
Yes.
This is by the headmaster of the school. This is to Ron has requested to take necessary action and initiate investigation at the earliest. This is how it has been said into motion, madam. Now, from page 15 onwards, my lord will see the seizures.
Yes.
This is, my lord, some old clothes, shirts and all, my lord. The seizure witness who is one BC Lago, who is the headmaster, my lord. Another is C. Chuku, your lordship will not, my lord will kindly know that he was not examined. C. Chuku is not examined.
One was examined.
One is examined.
Okay.
Then the next page is, my lord, the seizure pertaining to a motorcycle. One is not examined. Two is examined. Then, my lord will see the weapon of offense at page 17. My lord, I will read this, my lord. I, Sri T. Tagu, SI, SEPA PS, do hereby seize the below noted, the suspected weapon of offense belongs to Sri Apotaching, not examined. It's a
Belongs
post-up
to?
trial. He says the weapon of offense actually belongs to one Apotaching. Sri Apotaching, your lordship, kindly see. Seize the below noted suspected weapon of offense belongs to Apotaching.
No, he is not cited as witness also here.
Yes. But he would have been a vital witness. It says the weapon of offense was his. He is the owner of the weapon of offense. I'm just pointing out he is not examined, madam. From the house of Srimati Uming Tachang. Yes, he has been examined. Now, these two seizure witnesses, Sunil Namam and Tai Namam, they are not examined.
They are examined.
No. So the weapon of offense was seized.
Whether the weapon of offense was sent to the FSL?
No. Doesn't appear from the record.
No, what the IO has deposed?
He says, because there was no blood stains, that is why I did not send it.
Whether the same was shown to the doctor, medical officer?
From the evidence, it does not reflect so. Basically appears to be a post-up trial and
Basically.
investigation. Post-up investigation they appears so. So these two persons are not examined also, these seizure witnesses. And the weapon of offense itself was never exhibited. Next page is pertains to my lord one motorcycle. These two are not examined. At page 19 is a seizure list pertaining to one torch, 2 cells. The person at serial number 2, who is a police officer, he was not examined. Page 19. At page 20, there were 2 persons, my lord, accused persons. One of them passed away.
One is passed away.
Yes. This is another seizure list of the weapon of offense. I, Sri T. Tagbu, SIPS, SEPA PS, do hereby seize the below noted weapon of offense produced by one Sri Tamang Tanam. I will kindly note this because this person denies it later on. Of such a way, reportedly such and such, which was reportedly snatched by Sri Tadaptok from the position of Sri Mayang Techi. These two names, Mayang Techi and Tamang Tanam, I will kindly know. Tadaptok is the accused person, to the appellant minor, from the position of Sri Mayang Techi at Palak village in connection with such and such. Now, of this, the second seizure witness is not examined. Then the lordships may kindly come to the depositions manner. It starts from page 70.
Page number
70 manner.
70.
70 manner. PW1.
Yes.
I am appearing in the present case as witness. On 5/12/2003, I was at my native village. I am serving at Power Department as peon. I know the person standing on the dock. One is Bhaskar Tok and other is Apotachang. They are my neighbor. PP wants to reserve the exam after examining the IO. Reserved. Then, in the next page, PW1, same person, man.
No. Same person.
Same person.
Okay.
I know the accused person is standing on the dock. He is from my locality. I can identify my signature in the seizure list through which Thor's battery was seized by police. But I cannot remember about the same as the incident took place before about 20 years. I do not give statement to police. I have not stated before police that I have seen Tadaptok dropping Fukonsar on bike before the day of incident. Fukonsar is the minor deceased. He was a teacher. So he's denied it. It is not a fact that when I was trying to drive the bike of Tadaptok, he has shown one dagger. He was not even declared hostile. He's a prosecution witness.
No, how this suggestion lies in the examination in chief?
My lord. I don't know.
Okay.
So this is the statement basically. So at
Next.
page 72 is the informant, my lord, the headmaster. I am appearing in the present case as witness. During 2002 to 2003, I was posted at Pakke Kesang as headmaster in government secondary school. On 6/12/2003, early one morning, one school captain, Takam Nabo, informed me about the murder of assistant late such and such. He was holding the charge of warden of guards hostel. I informed the incident to the school management committee headed by Circle Officer C. Chuku. I sent Sri T. Wage 88 to Sagari to inform the DC, SP, etc. I also sent two students, namely Tadaptok and Taso Taku, with my bike with written FIR in my name addressing to OCPS SEPA. So, my lord, one of the students sent along with the FIR was, my lord, the accused person, my lord, appellant, Tadaptok. In my name addressing to OC SEPA and copy to DC, DDSC, and SP. Mr. T. Wage came back and reported to me that he has sent a letter to SDO to make WT. I saw the dead body of the deceased from the main door, who was lying stretched on his bed. I instructed the other person not to enter inside the room until the police was arrived. On the next day, the IO, Mr. T. Tagu, came at PO. I saw the injury of the deceased. Deceased sustained injury on his chest, which is a stab injury by a dagger. The household articles and books were found in scattered manner. The motive of the offense is narrated in my FIR, which is relating to the stipend money of the students amounting to rupees such and such, which was drawn by the deceased. The accused Tadaptok knew all about this transaction as he accompanied the deceased for withdrawal. The accused Tadaptok was my student at the point of time, which was reading class 8. I do not know the other accused, Apotacha, who was not my student. He may be from SEPA. I do not remember the accused standing on the dock. The amount was not robbed by the miscreants, and it was deposited to one of the senior teacher, Mr. K. Roy, who was having family. Later on, the amount was handed over to CO Pakke. After 2 days of incident, I have noticed that the office room was also damaged and the locker was also broken. This was order from director to close the hostel. 2 girls were enquired at IB. They were taken away to SEPA. I know from this stage of this case, the person wants the affairs, such and such, such and such. Then matter will come to the defense. a crossback. It is true that I am not eyewitness to the incident. As per my personal knowledge, I do not know the name of the accused. I do not know whether the motive of the offense could be another reason apart from my statement in chief. The PO is more than 200 meters away from the quarter. I do not have any proof to show that the accused Tadatok accompanied deceased Sepa after engaged them to collect the stipend amount. So he has also not seen the accused person accompanying the deceased person.
But one thing is apparent from his evidence
Yes,
that he engaged the accused
yes.
to collect the stipend amount.
No, no. The
This
stipend amount,
last sentence, last part of the sentence.
uh,
After I engaged them to collect the stipend amount.
my lord is reading the chief part. Man.
No, there's a cross part. Last sentence.
Yes. 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 But the fact that whether the accused person went along with the deceased person, there is no evidence to that effect.
No, that is a different
Yes.
aspect. But the fact remains that he was engaged with the accused to collect the stipend.
Yes.
Stipend
To
stipend
go along. He was a student, my lord. He was a class A student.
Mm.
Student of class A. Then, my lord, PW3.
Mm.
I'm appearing in the present case as witness. Next page, my lord.
Mm.
I know the person is standing on a dock, but I do not know who is standing on the dock. I have not given a statement to the police. I was captain of Government Higher Secondary School, Pakekesang, during 2003. I forgot the name of the headmaster. I do not know headmaster is alive or not. So only this much.
Mm.
Then PW4. I am appearing in the present case as witness. I do not know the person is standing in the dock, but he was traveling with me while coming from Sefa. I have not given a statement to the police, declared hostile, crossed by PP. It is not a fact that the accused standing on the dock belongs to my village. I know the accused Apotachang alias Techi, he is now in Itanagar. It is not a fact that I have given a statement to police. It is not fact that I deposed before the police that Apotachang sold a dagger to Bidanamo, who was riding a motorcycle near Tadap's house. It is not fact. I heard the argument between the accused Apotachang and Bidanamo relating to dagger. It is not fact that I told the police that Apotachang was showing dagger to Bidanamo.
Whether the statement made by this witness
Well,
before the IO was brought on record by examining the IO?
I no, my lord.
No.
No.
Okay.
Trial, my lord. Here, my lord, sometimes these things happen. That's difficult. Then PW5. Mayang Techi, my lord, I had pointed out her name earlier. She has said nothing. At page 76.
Mm.
And page 77. She is one of the women, my lord, from purportedly from whose house the weapon, one of the weapon of offense was recovered. I am appearing in the present case as witness. I am elder sister of accused Apotachang. I do not know my brother is present. Police have been declared hostile. It is not fact the weapon of offense recovered from my house by police. It is not fact that P.I. Taina and Sunil came to my house with the police. It is not fact that I am giving false statements, such and such, such and such. Then 78, PW7, Tanatama, who purportedly, my lord, brought the weapon of offense to the police.
Mm.
That is in the seizure
Mm.
document. I am appearing in the present case as witness. In 2003, I was at my village, Sochong. I do not know the accused is standing on the dock, declared hostile. It is not the fact that I know Apitechi. It is not the fact that I was present at the time of recovery of weapon of offense from the house of Tadap Tok. It is not fact that Apitechi disclosed me that Tadap Tok forcibly took away the weapon of offense. It is not fact that I, along with Apitechi, to recover weapon of offense with Tadap Tok. It is not fact that I have given exact date to the police about the recovery of weapon of offense from Tadap Tok. It is not fact I am giving false such and such, such and such. These are the witnesses, my lord. There are thereafter only the official witnesses.
PW 8 is the IO.
Ayo. Here also, my lord, will see, he was confronted with the 161 statement also was not placed before him. I-79. I am appearing in the present case as IO in the case in connection with under section 302 IPC case. I have visited the PO. I took photographs of PO and deceased. I have recorded the statement of such and such, such and such, such and such. After a recovery of dead body from PO, I have sent the dead body for PME. The motive of the offense was for the purpose of taking stipend which escaped the house of the deceased. The house offense was committed on such and the weapon was seized. My lord will kindly know. The weapon of offense was seized by me. I have seized wearing apparel of deceased, 2 numbers of dagger weapons of the offense, 2 numbers of bike, whatever drill, such and such, such and such. On the basis of statement of witnesses seized items, PME, confidence statements, I have charge sheeted 2 such and such. So this is his statement. Thereafter is his exhibits. Paper exhibit 1, signature of OC, D. Gini, which I have exhibited. PX8 is format of FIR. PX8A, signature of D. Gini. PX9 CS, PX9A signature are my signature on it. 5B is my signature. Just 10 is seizure list of 1 dagger measuring is my signature on it. PX6B is my signature on figure. 11 is seizure list of 1 Suzuki Shaolin. There's a motorcycle. And PX11 is my signature on it. Is a seizure ever ready torch is my PX13 is seizure list of 1 dagger measuring such and such, wearing apparel of deceased was corrected such and such. Before me, PX10, 1 dagger has been recovered from the house of community in disclosed accused, and PX611 bike were recovered from accused of the incident, but later on during the investigation it was disclosed that the seized bike was used as transporter to collect stipend from SEPA. The torch was recovered from the house of Tadaptok in the presence of Bidanamam, ASI, Tidigung on the disclosure made by accused Tadaptok during investigation. It was revealed that the dawa was taken by Tamang Tana from the house of accused Tadaptok. It was snatched by Tadaptok from the possession of Mayang Techi. The dawa actually belongs to Tamang Tana. Is the signature of PX, Jimma of Yamaha, Jimma, signature of Gadisa, PME reports collected, is a signature of Gogoi, that an SMO. Is a confessional statement of accused Apotachang, is the confessional statement of accused Tadaptok. PX18 is inquest report. 18A is my signature. PX19 is rough sketch map. 19A signature. PX20 arrest memo. PX20A signature. 21 arrest memo. 21 a signature. 22 crime detail. 22 A and B signatures. PX is docketing of PX is my signature. 24 is suspending of accused person and PX20 is signature. 25 is accused chalan by DG 25 is signature. PX26 forwarding such and such method. None of the materials are exhibited.
Okay, let us see the confessional statement.
Yes.
Page
Confessional
number?
statement, my lord, he has said so.
Page number?
16. Page number is 31. Here he has confessed, apparently. From the 3rd paragraph onwards, so you'll find. The difficulty is, my lord, there is no corroboration to this, and this has been retracted by the appellant during 313.
Who had recorded the confessional statement?
That was at that point of time, my lord, they were executive officers, actually. It would be an
Whether
express-
time of reflection was given?
that he has said so here. At page number 34, your lordship will find.
34.
Yes, it's a format. The only thing your one, this is not very legible. I have not been able to make out. It is not very clear as to whether the contents were read out to the accused persons or not. At page 33. That is not very clear. I can't make it out because it's not legible. Second, I was recorded by me and explained to him in the language sentences and I'm not sure whether the accused person has my lord admitted to the correctness of the statement. In any case, my lord, there is no corroboration to the 164 statement. My lord.
No, whether the person who had recorded this confessional statement was examined?
Yes, he was examined. He was examined.
PW 9,
PW 11, my lord.
11.
Yes.
Page number
PW 9, my lord. I'm sorry. PW 9, 83.
83.
83. Now, your lordship will kindly note, he says in the clause, I do not exactly remember how much time was given to accused for relaxation and reflection, but I usually grant half an hour time for relaxation.
But in such a serious offense, whether half an hour
Yes.
time for reflection is sufficient? Any other point?
No, my lord. This is the PW 10 is the, my lord, one of teacher is apparently not the eyewitness. 11 is the, my lord, doctor. Independent witnesses are up to 7, my lord. 11, they have examined 11 witnesses. 11 is a doctor, 10 is one of the teachers in whose house the money was kept. He has said nothing incriminating against the accused.
So it appears that the headmaster
Yes.
has endorsed him with the disease
Yes.
to collect the stipendary amount of the student.
Yes. But thereafter, there is absolutely no witness. This is the failure on the part of the prosecution to even suggest that the accused person actually went along with the deceased person because the stipend has to be taken from the headquarters, my lord. Some witnesses from there that he came along with the deceased person and he was there when the money was collected. There is absolutely no evidence, my lord. So on the basis of such evidence, my lord, whether, my lord, a conviction under 302 can be sustained,
No,
my
may
lord.
not be. But whether this circumstance, this part of evidence, this piece of evidence of the headmaster
My lord.
would not corroborate the confessional statement of the accused?
No, my lord, in my humble submission, my lord, because the statement of the headmaster does not say that he actually went. There is no corroboration to the fact.
And
Because I have
further,
denied, I have retracted that 164 statement. There is no other evidence to corroborate the 164 statement now. Now, what the headmaster says is only to the effect that I had assigned him to go along with him. Then the fact remains that they are saying two persons were there. And it is not a case that the crime, my lord, was committed when on the road, my lord.
no, it was in the midnight.
Yes, it was at home, back home, in his quarter. government accommodation.
Mm.
So this does not prove anything, my lord, in my humble submission.
And the headmaster also deposed that he found the household articles of the deceased scattered in his quarter.
Yes.
Is this not a corroborating piece of evidence to the confessional statement of the accused that he searched the amount in the almirah of the deceased, but he could not found it out?
My lord, in my humble submission, my lord, if the headmaster had said at deposed, even remotely linking me to that part, that the house of the deceased person was scattered and somebody has told me I had seen him coming or something like that, but then, my lord, there would have been corroboration, my lord. There is absolutely no corroboration in my humble understanding.
Yes, madam.
My lord, can I rely upon some judgments, my lord?
Yes.
My arguments are threefold, my lord. Basically, 164 statement, my lord, it has to be corroborated, so there is absolutely no corroboration. So on the basis of the 164 statement, there cannot be any conviction. Second, my lord, is that vital witnesses has not been examined, that makes the cases of the prosecution weak. And since the weapon of the offense has not been, my lord, produced before the honorable court, it is fatal to the prosecution's case. On this line, my lord, I am relying upon 6 judgments, but I will read only one, and the other ones I will give the paragraphs, my lord. This is my lord 1973 SCC. This is the leading case on my lord. Yes, sir. This has been followed, my lord, subsequently in all cases, my lord. My lord knows this, my lord, is not a substantial piece of evidence. I will not read paragraph 8, my lord. Statement under section is not a substantive evidence. It can be used to corroborate the statement of a witness with the settled law, my lord. Another one on this point, my lord, 2010 6 SCC 493, paragraph 14 to 16. Paragraph 14 to 16. For 64, my lord, is settled law, my lord, so I am not bothering your lordships. Then, my lord, non-examination of witnesses. First one is, my lord, 2001 6 SCC 145. I would like to read it, my lord.
This 2010 paragraph?
2001 6 SCC.
No, 2010 paragraph, which paragraph?
2010, my lord, 14 to 16.
Okay.
You have marked the paragraphs here?
No, I have not marked, my lord. I'm sorry, shall I mark it, my lord?
Oh, yes.
I'll mark it, my lord.
Okay.
My lord, 2001 6 SCC 145. Para 19. Yes, my lord, go to paragraph 19. Yes, my lord, got it, my lord. Paragraph 9. So is the case with the criticism leveled by the High Court on the prosecution case finding fault there for non-examination of independent witnesses. It is true that if a material witness who would unfold the genesis of the incident or an essential part of the prosecution case not convincingly brought to the fore otherwise, or there is a gap or infirmity in the prosecution case which would have been supplied or made good by examining the witnesses who, though available, is not examined, the prosecution case can be termed as suffering from a deficiency, and withholding of such a material witness would oblige the court to draw an adverse inference against the prosecution by holding that if the witness would have been examined, it would not have supported the prosecution's case. My lord, I've seen so many prosecution with seizure witnesses who were purportedly, my lord, witnesses to the seizure of the weapon of offense were not examined, my lord. And that included, my lord, a officer of the police, ASI. The second case is, my lord, 2015, 11 SCC, page 52, para 36. Mark to 36. Yes. On the same line, my lord, that if the prosecution does not produce independent witnesses, adverse inference will be drawn. Para 36. And my lord, no, the Honorable Supreme Court has always held, my lord, especially in heinous offenses, my lord, when the punishment is also, my lord, higher. Then, my lord, the evidences will have to be examined more pointedly. Then, my lord, regarding material witnesses, non-exhibiting material exhibits, 1997, 10 SCC, 44, paragraph 8. Stomach 38, 39, 40. I am reading a judgment of our own High Court on the same point, my lord, 2005, 4 GLT, page 86. I've given the paragraphs, I'm not borrowing a lot. This is from our state only, man. 38. In the case of Muhammad Aman and another versus State of Rajasthan, the apex court noticing the seized articles which could be best evidence of proof of the claim of seizure having not been produced and exhibited during the trial was fatal to the prosecution's case. In the instant case also, apart from non-production, the most important article, that is the dao or knife, allegedly used by the accused appellant, coupled with defense version that injury sustained victims from made by prosecution weak. In the case of Calicut Kunhu versus State of Kerala, the eyewitness stated the dagger was used to inflict injuries upon the deceased. Here was a witness that said that the dagger was used to inflict injuries upon the deceased. However, the apex court found that if that be so, the dagger could not have been enclosed in a sheath. It should have been found unsheathed and ought to have some bloodstains. Under these circumstances, the apex court held that the same strongly probabilized the versions put for the appellant the incident did not take place in the manner narrated by it was observed by the apex court. If dagger was not used to inflict injury, there is no weapon of offense produced before the learned trial court. In the instant case also, apart from the fact that these articles were not produced, most importantly, the weapon allegedly used by the accused appellant, it is also not the case the prosecution there were blood stains. But kindly note here also, the IO in his statement has said he has not sent it to FSL because there were no blood stains in the cross manner. All these factors have rendered the prosecution case highly improbable. As observed earlier, no amount of suspicion, however strong as it can lead to any conviction. In the instant case also, there might be suspicion about the conduct of the accused appellant, but at the same time, having regard to the fact that there were inherent contradictions in the prosecution case, coupled with the fatal discrepancy of non-production of seized articles, more particularly the dao or knife allegedly used by the accused appellant, has made the prosecution case weak. In such circumstances, it could be said that the offense allegedly on the accused cannot be said has been proved beyond reasonable doubt. here is a case, my lord, forget about my lord contradiction, when there's not a single witness, my lord, that even remotely suggests that the crime was committed by the accused. That is my humble submission, my lord. This division bench judgment, my lord, in my humble submission, my lord, categorically covers the case of the appellant.
Where is the 313 statement of the accused?
313 is just a moment. At page 64. Question number 8, page 66. Eight,
Question
nine,
number 6.
8. Oh, my lord, sorry. So one. It is at page 66, my lord. This is relevant. PW8, my lord, at top. Titagu Ayo. Deposed that the weapon of offense was seized by him. He has seized wearing apparel of deceased, 2 numbers of daggers, weapons of offense, 2 numbers of bikes, such and such, such and such. He said it is not true.
No. There's a confessional statement where the question was put.
Yes, next question.
Where he denied his confessional statement.
Abu Tang deposed that he has recorded a confession statement by accused Apa Tachang and you. He has followed the due process of law before and after recording statements. As per the accused Apa Tachang, he committed the offense and such and such. He says it is not true. Next question also.
Okay. Yes, madam.
My humble submission, my lord, the paragraph 40 of the division bench judgment, my lord, 38 to 40. Okay.
May Lordship. Lordship, here Lordship, the statement of Lordship, PW2 Lordship, with the headmaster. Lordship, here Lordship, we can see in his statement Lordship, he acknowledged that the accused Tadap Tok knew all those transactions in his statement Lordship, as he accompanied the disease for withdrawal. Lordship, this can be Lordship, can be corroborated Lordship. In the page Lordship 72. May I, Lordship? Lordship, I am appearing in the present case as witness. During 2002 to 2003, I was posted at Pakistan as headmaster in government secondary school. On 6/12/2003, early morning, one school captain, Takam Nagum, informed me about the murder of assistant late P.K. Ukan. He was holding the charge of warden of girls' hostel. I informed the incident to school managing committee headed by Circle Officer C. Chuku. I sent Sriti Wage, ATA to Sagali to inform the DC, SP, etc. I also sent 2 students, namely Tadap Tok and Taso Taku, with my bike with written FIR in my name, addressing to OC, PS, SEPA, and copy to DC, DDD, SC, and SP. Mr. T. Wage came back and reported me that he has sent the letter to SDO to make WT. Only T. Wage came back, Lordship. I saw the dead body of the deceased from the main door, which was lying stretched on his bed. I instructed the other person not to enter inside the room until the police was arrived. On the next day, the IO, Mr. T. Tagu, came at PO. I saw the injury of the deceased. Deceased sustained injury on his chest. Lordship, it can be marked, Lordship. injury on his chest, which was stab injury by a dagger. The household articles and books were found scattered manner. The motive of the offense is narrated in my FIR, which is relating to the stipend money of the students amounting to rupees 1,77,000, which was drawn by the disease. Then again, Lordship, here then my Lordship, the main point, Lordship, accused Tadap Tok knew all those transactions as he accompanied the disease for withdrawn. Here, Lordship, accused Tadap Tok was my student at the point of the time who was reading in the class 8. I do not know the other accused Apo Tachang who was not my student. He may be from Sepa. I do not recognize the accused standing on the dock. The amount was not robbed by the miscreant and it was deposited to one of the senior teacher, Mr. K. Roy, who was having family. Later on, the amount was handed over to the CEO Pake. After 2 days of the incident, I noticed that my office room was also damaged and the locker was broken. There was order from the director to close the hostel. 2 girls were inquired this. I know up to this stage, Lordship. And Lordship, the defense, Lordship, it is there, Lordship. It is true that I'm not eyewitness of the incident. Obviously, Lordship, he cannot be eyewitness, Lordship. That incident was took place in the midnight, Lordship. So as per my personal knowledge, I do not know the name of the accused because that accused is not, he was talking about the Tadap Tok. He must be talking about the Apo Tachang, Lordship, which is already stated that the other student, other co-accused, he doesn't know. The motive, I do not know whether the motive of the offense could be another reason apart from my statement in chief. The PO is more than 200 meters away from the quarter. I do not have any proof, so the accused are to accompany up to say I engage them to collect. Lordship, do not envy the accused to the Lordship here, Lordship, his defense Lordship statement, Lordship, is bit contradictory, Lordship, because he, Lordship, already stated that he sent the accused person, the 2 student, Lordship, to beat his bike, Lordship. And Lordship, moreover, Lordship, he already, Lordship, make a statement that the accused person knew the order, all the transaction, and he accompanied the disease for withdrawn. That is their, Lordship. His statement, Lordship, already clearly stated that the accused person, Lordship, he knew the transaction, Lordship, and he also accompanied the disease for withdrawn. That is clearly stated, Lordship. And Lordship,
No, but whether any person has seen them proceeding to withdraw the amount?
Lordship, that is, Lordship, not clear, Lordship, because Lordship, when you, Lordship, a person send 2 person, it not necessary that Lordship, other person will, Lordship, take notice of that, or Lordship,
No, no.
because
Someone has to see. Unless, how can it be said that?
Lordship and Lordship,
How can it be said that the case has been proved beyond all reasonable doubt?
and Lordship, we'll go to the Lordship, the confessional statement, Lordship, of the accused, Lordship. On the page, Lordship, 27, Lordship. Tidak 27, Lordship. I'll go to 31, Lordship. The accused, Lordship, the present accused, Lordship. Confessor statement of Tadap Tok, Lordship. May, Lordship. On 2/12/23, I left Pakistan with Pukan Sir, Lordship. Here's statement, Lordship. Pukan Sir is the headmaster. On a motorcycle, I stayed in Apo Tachang house. That he is the co-accused. On here, Lordship, he confessed, Lordship, that on 2/3 he left with the Pukan Sir on motorcycle and stayed in the Apo Tachang house. On 3/12/23, I discussed with Apo that I came to Sepa with Pukan Sir for collecting huge stipend money and we should rob the money from Pukan Sir. I left Sepa on this 4/12/23 around 4 p.m. with Pukan Sir and took food at Palin. We stayed at Rilo and reached Pakistan around 9 hours. After reaching Pakistan, along with Apo, went to Palab village and returned in the evening. We drank wine and discussed with him to rob with stipend money, which might have been kept at office of the headmaster. At about 9 p.m., we went to school and entered the office of the ceiling and opened the almirah. Lordship, that is their lordship, because already the headmaster was stated that his office, this something was broken, lordship. That is in statement also, lordship, in the similar lordship. We found nothing, so went back to my house. There we drank some more and then decided to take the money from Pukan sir's house. It was about 2:30 a.m. We went for the window and managed to get one open and one bar. And as one bar was not there, we entered through it. I took sir's torch from near his pillow and searched for the money but could not find it. As I was opening the almirah, Pukan sir woke up and recognizing me, shouted, "Tada paisa nahi hai." I gagged his mouth with my hand and stabbed him. In the meantime, I called Apu, who was in the next room, and told him to help me kill sir. He came and at my instance, he also stabbed Pukan sir using the dagger he had with him. I am not sure about the number of times me and Tada stabbed sir, as we both were nervous and it was dark. I did not let go Pukan sir from my hold till I was sure of his death. After that, we looked around for the money but did not find it. After that, we came out from the quarter and I helped Apo push his bike up the hill, as we feared that starting it would alert everybody. That means, lordship, no one was there, lordship, only both of them. On the way, I threw my dagger away, but I am not so sure about it. After reaching home, I went to sleep. I woke up in the morning. Till then, the news about Pukan's murder had spread. As I accompanied him to Sepa to avoid suspicion, I decided to go down to Sepa to report the matter to police. So I came to...
That's all right,
Yes,
Madam.
lordship.
See, though the confessional statement is there,
Yes, lordship.
but it appears that sufficient time was not given to him for reflection. Here, only 1 hour was given to him for reflection. Whether this 1 hour period is sufficient?
Lordship, that is, lordship, at that time, lordship, how that process was done, lordship, we have no idea, lordship. Because that time, lordship, maybe that much time was, lordship, sufficient, lordship. Otherwise, lordship, that could have raised the, like during the trial process, lordship.
No. You say here there is no direct evidence.
Yes, lordship.
Except the confessional statement,
Yes,
no
sir.
other evidence.
Lordship,
Is there.
circumstantial evidence, lordship, because, lordship, here, lordship, his statement, lordship, he already confessed that that he killed that headmaster, lordship. And lordship, moreover, lordship, that injury report, lordship, injury you also have to ascertain, lordship, how that injury caused to him, lordship. We will go to the lordship injury report, lordship.
No, that's all right. You say here the dagger was seized, but it was not sent to the FSL for examination, and it was also not produced before the
Lordship,
court.
actually, lordship, the very, lordship, weak point was that, lordship, the investigation part was done properly, sir, except that not that have sent to the FSL, lordship. Otherwise, lordship, seizure was done, lordship, and lordship, their confession was also been recorded, lordship, and lordship, PO or been examined, lordship, or was done, lordship. In the meantime, what has happened, lordship, in the trial, lordship, some of them become hostile and some of them change their statement. And lordship, but the conviction was based on the lordship, this one, lordship, section 30 of evidence, lordship, and the section 80, lordship, where there's confession statement, lordship, there had been, lordship, given the lordship importance, lordship. And lordship, moreover, lordship, here, lordship, in the lordship,
Section 30 of the evidence.
yes, lordship, 30 of evidence, yes. 30 of evidence, yes, lordship.
The statement given by the other person.
Yes, the other person, lordship, because both the co-accused, lordship, their statements are similar. Their confession statement is almost similar, because they both are there together. And lordship, moreover, lordship, we have to see, lordship, the section 302 IPC, we have to see the motive, lordship. Whenever someone kills someone, lordship, there should be some motive. Intention should be there, lordship.
No.
And here, lordship, you
On
have
the basis of motive, you cannot establish your case.
no, lordship, we just have to just corroboration, lordship. This is, lordship, that is a part of the lordship. Motive is behind that, lordship. They have already know that Stephen money is with him, and that in their confession statement also, lordship, they have confessed that because of this thing, lordship, that they killed that this accused, deceased person, Lordship.
Mm.
And also, moreover, Lordship, in the section 80 of Evidence Act, Lordship, the position to document produce record of evidence, Lordship. That is also, they have
Pardon?
the section 80 of evidence,
Mm.
which is stated that presumption as to documents produced as record of evidence, which the trial court has, Lordship, make note of it, Lordship. Whenever any document is produced before any court, purporting to a record or memorandum of the evidence or any of the part of evidence given by witness in the judicial proceeding or before any officer authorized by law to take such evidence or to be statement or confession by any prisoner or accused person taken in accordance with law and purporting to be signed by any judge or magistrate or any such officer, the court shall presume the document is genuine. So that's why, Lordship, that confession statement, Lordship, is a part of, Lordship, genuine document, which is, Lordship, they have, Lordship, recorded before the, Lordship, magistrate.
No, that's all right. It was recorded before the magistrate. But the question of sufficient time for reflection.
Lordship, here, Lordship, again, Lordship, will go to the, Lordship, the witness, Lordship, the witness statement, Lordship. Here, Lordship, one, Lordship. First of all, Lordship, this this one, Lordship, seizure witness, Lordship, page 90, Vidan Abum. From where this everyday torch cell, no, that it was recovered, Lordship. This person also, Lordship, that accused in his 313, he confessed that he knows this person, Lordship. And Lordship, from where that that seizure was, Lordship, made, Lordship, in the presence of his Lordship. And Lordship, moreover, Lordship, one more, Lordship, lady, Lordship.
No, the question is whether there is a link that the seized weapon was used in the offense.
Yes, Lordship, we'll see, so go to page 20, Lordship, this seizure list, Lordship. May, Lordship, page 20, Lordship. Lordship, I stated as I said, but we have seized the below noted weapon of offense produced by one Sri Tamang Tana of Sachung will reportedly taken from the house of Sri Tadap Tok, which the accused on the morning on the request of Srimati Api Techi, who was reportedly snatched by Sri Tadap Tok from the possession of Sri Maying Techi at Palab in the collection this date in the presence of following witnesses. One dagger, Lordship. The dagger, Lordship, this is seized, Lordship. The witness in the here, Lordship, the witnesses was Lordship Tamang Tana and Damung Plego. But the Damung Plego statement was not recorded. But Tamang Tana statement was recorded. Tamang Tana statement recorded, Lordship, in the page, Lordship, 78, Lordship. Here, Lordship, he become hostile, Lordship.
That's all right, but whether his statement given before the police officer was confirmed by the IO.
Lordship, this
That has
161 statement, Lordship, in here we have no available, Lordship, in the paper book, Lordship.
No, the question is
Yes, Lordship.
whenever the witness is declared hostile,
Yes, Lordship.
his statement made before the police officer has to be brought on record by examining the IO.
Yes, Lordship.
And there is also requirement of exhibiting that portion. Then you have to explain to the accused that, see, you have made such a statement before the police officer. What you have to say on this?
Lordship, for that we have to go
Where
to
is
the
where
IO
is that,
statement, Lordship.
Pardon?
IO statement, Lordship.
Not there, man. We're already ready.
May, Lordship, page 79. I'm appearing the presence case IO of the case. During investigation, I have visited the place of occurrence. I took photograph and recorded statement of BC recorded that the statement was recorded, Lordship. Bidan Nambu, Mia Techi, Sente, Taban Nabun, Taban Nakon, Tamang Tana, Punit, and that all is recorded. The motive of offense was for purpose of taking stabbing, which was kept in the house of the deceased. The offense was committed on the weapon of also seized by me, and I have seized wearing apparel of DG, 2 number of dagger weapon of the offense, 2 number of bikes, 1 library torch, and also have collected PME and 2 number of confession statement. On the basis of statement of witness, seized items lawsuit. PME confession statement, photographs of PO. I have charged sheeted 2 accused. That is about the accused. I cannot identify the accused person standing on the dock as it is long case. Signature of the OC, which the exhibit also received the signature of the DDD, signature of this, and the signature of this, and the lordship signature lordship, they have already lordship, the seizure was done lordship. And lordship, next page lordship, page 80. Bike was recovered from the accused as they came to PS as informer of the incident, but later on during the investigation, it was disclosed that the seizure bike was used as transporter to collect stuffing from the SEPA. The Dodge was recovered from the house of the Tadap Tok in presence of Bidan Nabung. And ASIT, the disclosure made by the accused Tadap Tok. During investigation, it was revealed that the dog was taken by the Tamang Tana from the house of accused Tadap Tok, and it was snatched by Tadap Tok from the possessor of Mayang Techi. Lordship, that Mayang Techi, Lordship, her statement was very crucial, Lordship, but she became hostile.
No, that's why.
Yes, Lordship. And the
Her statement is not
Yes,
brought on
Lordship.
record by examining the IO.
And Lordship, that dao was actually belongs to Tamang Tana. It is that the signature or the recorded Lordship. The accused channel or record the fact, the defense lawsuit will go to defense. It is a fact that there was no eyewitness in the case. It is a fact that the seized weapons was not produced in the court today. It is not a fact the CS charges of the accused are recorded during their police custody. It may be true that the confessional statement of the accused were recorded after 12 days of police custody. It is a fact that the weapon of the offense of dagger was belonged to Tamang Tana. It is fact that it was not recovered from the accused but recovered on his late lordship. That means lordship, section 27 of the Evidence Act lordship, disclosure of the evidence lordship through the accused person lordship.
No, whether
It's
such
effective,
statement was recorded.
Lordship,
Disclosure statement.
process lordship, that was lordship.
Hmm.
We have to go to the lordship that 161 and the all the
No,
lordship,
no.
lordship.
To apply section 27, that disclosure statement has to be there and has to be recorded before recovery of the weapon of offense.
Yes, lordship. That part to lordship.
Not there.
Yes, lordship.
Not there. And the procedure of declaring a witness hostile is also not followed.
Yes, lordship.
How long the accused is behind the bar?
Since 2023.
23.
Yes, it was on testimony.
Lordship, the
May.
case is clear, Lordship. They are Lordship culprit,
No,
Lordship.
case
But
is
the thing
clear,
is, Lordship,
but
proper
where's the
Lordship
evidence?
trial was not done, Lordship. That's the loophole, Lordship.
On that count alone, my lord, appeal learned PP is saying crime was done, but trial was done properly. How can we say as lawyers
But
something like that?
Lordship, basically, Lordship, because of lack of prosecution, Lordship, certain Lordship, criminal Lordship, they escape, Lordship. That is very sad part, Lordship. But Lordship, yes, Lordship, I know, Lordship, because the trial, Lordship, whatever the decision will be made by the Honorable Court, Lord, is basis of that all the Lordship, witnesses, prosecution, all Lordship. But I am not saying that Lordship, by blindly Lordship will pass an order, Lordship. But the Lordship go to all the Lordship evidences, Lordship, the prosecution, whether there may be some lawful Lordship.
Ultimate question is whether the evidence available on the record is sufficient to establish the case of the prosecution beyond all reasonable doubt.
Yes, Lordship.
That is the question.
Lordship, moreover, Lordship, I have submitted Lordship before the Lordship for a reference Lordship where the Lordship conviction was upheld Lordship on the complete and unbroken chain of circumstantial evidence Lordship.
Exactly.
Pardon?
The conviction was Lordship upheld Lordship. Although there was unbroken, there was Lordship.
There was
Lordship some missing link. Release Lordship link was there Lordship.
missing link.
Yes, Lordship.
But where is the sign of?
Where lordship, the motive lordship, main lordship motive is lordship. We have to go to lordship.
No, motive is not relevant when direct evidence is available. Motive is only relevant when the case is, prosecution case is based on circumstantial evidence.
Lordship, here,
Where is the other circumstantial evidence?
yes, lordship, here, lordship, only the evidence, lordship, that headmaster, lordship, who sent that boy to lordship with that, the diseased person, lordship, that is their lordship. And moreover, lordship, it is true that lordship, that no eyewitness should be there, lordship, because that incident was took part in the midnight, lordship. Yes, lordship.
Midnight, yes.
And lordship, then why lordship confession statement will be like that, lordship? Why that boy will say that I'll kill that?
That's all right. But he had subsequently denied that statement in his examination under section 313 CRPC.
313, lordship.
Yes, he
Yes,
denied.
lordship, because moreover, lordship, 313, usually, lordship,
retracted.
everyone deny, lordship, no one, lordship.
Hmm?
Usually 313 statement, lordship,
Hmm.
they, lordship, but lordship, in the 313, he accepted that he know that treasure witness one, lordship.
Hmm.
And rest of the part, lordship, he is not, lordship, or no, I don't know, lordship, he denied, lordship.
Hmm. No. Mr. Panging has already read out that part of statement under section 313.
Yes, lordship.
If I may just point out, my lord, one thing, you cannot be speculating because the headmaster says he has assigned two persons,
Hmm.
not only me. There's another person named Taso Taku.
Hmm.
Thereafter, there is absolutely no evidence. And regarding section 30, my lord,
Hmm.
that other accused person whose confession statement as submitted by learned friend was taken into account to convict me. That would
No,
not
that
be
is not
that is not permissible, my lord.
Not permissible. That is not
Not
permissible.
permissible.
Okay.
Yes,
Right.
only the lordship, yes, lordship. The confession statement of the both the accused, lordship, they are similar, lordship, and
No,
the,
maybe.
My lord has
yes,
just said
lordship,
it is not permissible.
and lordship, no, lordship, but the lordship, the will go to the lordship, the PME report also, lordship, which is the PME report where that this injury was done, lordship, that the cause of injury, it is, lordship, corroborated with the statement of the accused, lordship, the confession statement. That lordship have to see that also, lordship.
Hmm.
I'm obliged, ma'am. I'm highly obliged.
Heard. Mr. D. Panging, learned counsel for the appellant. Ms. L. Hage, learned additional 50 for the state respondent. Argument concluded. Judgment reserved.
Obliged.
Right, lordship.
Pronouncement of judgment of item number 1.
This writ petition stands allowed.
Pronouncement of judgment, item number 2.
Petition dismissed.